Good morning, P.O. Kwasnick.
Parole Officer Kwasnick.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning A.M.Humes 347303. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robertson Correctional Institution. Please state your full name and DOC inmate number for the record.
Edward M. Humes III, and my inmate number is 347303.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney, as well as P.O. Kwasnick.
Good morning, Public Defender sorry.
No, go ahead, go ahead.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
Hello.
Looks like I lost P.O. Kwasnick. 1 second, I'm going to try calling him again. P.O. Kwasnick, are you there? You're muted if you are trying to speak. It looks like P.O. Kwasnick's phone keeps disconnecting, so I'm going to email him to see if he would like to try to participate via Teams. P.M. Kwasnick has requested that we hear him in about 20 minutes. He's on his way to the office. So he'll be able to be in front of his computer and hear and read the paperwork. He doesn't have anything in front of him because he's in the car. Is that okay, Attorney Famiglietti? If we hear him in about 20 minutes, I'll take the next hearing. So his PO could be present.
Sure. I mean,
Okay.
we got nothing but time, so.
All right, Mr. Humes, I will call you. I'm going to hear the next one waiting, and then I will call you right back in after he's done in about 20
Okay,
minutes.
so you're gonna do it
Okay.
right now? Okay.
Thank you.
Yeah, they said that they're.
Good morning, Mr. White.
Good morning, how you doing?
My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Veron White, 342707. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Veron White, my inmate number 342707.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Parole Officer Boisberg. Please introduce yourself.
Parole Officer Boisberg, Board of Parole Interstate.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony of today's hearing will be taken under oath. Mr. White and P.O. Boisberg, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. Do you intend to seek counsel for this hearing or proceed without?
No, ma'am.
You want to proceed without an attorney today?
Yes, ma'am.
Okay. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now review the charges that the state your parole officer is bringing against you and the information underlying each charge.
Charge 1, obedience to the law. On 5/3/2024, you tested positive for cocaine and admitted to the use of cocaine. This is a violation of Connecticut General Statute 21A-279, illegal possession of controlled substance other than cannabis. On 7/3/2024, you tested positive for cocaine. This is also a violation of Connecticut General Statute 21A-279, illegal possession of controlled substance other than cannabis.
Charge 2, drugs.
Drugs. On 5/3/2024, you admitted to your supervising PO that you used cocaine on 2 occasions after testing positive for cocaine. On 5/11/2024, the drug test results were returned, confirming the presence of cocaine in the sample. On 7/3/2024, you provided a drug test that was positive for cocaine. You denied any drug use, and the test was sent to the lab for further testing. On 7/9/2024, the drug test results were returned, confirming the presence of cocaine in the sample.
The state has filed the following exhibits.
Exhibit A, signed statement of understanding and agreement of conditions of parole. Exhibit B, special parole acknowledgement sheet. Exhibit C, notice of parole violation. Exhibit D, parole violation. Exhibit D, notice of parolee rights. Exhibit E, parole violation report. Exhibit F, remand to actual custody order. Exhibit G, ICOTS offender application for interstate transfer compact. Just for clarification, ICOTS is the system that states use to communicate between each other for interstate transfers. Exhibit H, ICOTS progress report dated 5/13/2024. Exhibit I, ICOTS violation report requiring retaking dated 7/11/2024. Exhibit J, Sober Solutions Counseling Discharge Summary Letter dated 7/8/2024. Exhibit K, Abbott drug test results, drug test report for 7/3/2024 drug test. Exhibit L, Abbott drug test report for 5/3/2024 drug test. Exhibit M, ICOTS addendum to violation report requiring retaking. Exhibit N, preliminary waiver.
Mr. White, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, ma'am.
And I also received your 2 support letters, one from Amanda Jo Freeman, and so that's defense exhibit number 1, which I marked up for marking for identification purposes, as well as exhibit 2, which is also a support letter from Kristen White. Were you aware of those letters being provided?
Yes, ma'am.
Okay, so I'm marking those for exhibits because I did review them in terms of your support for today. Okay.
All right, I appreciate it.
Today we have no witnesses. And now it is your opportunity to respond to the parole violation charges. However, remember that you may remain silent if you choose to do so. Do you wish to testify?
Yeah, yes, I want to talk.
Okay, well, before we do so, I'm going to actually allow the state to go first. P.O. Bosworth, if you would like to speak to any of the evidence presented or present any further evidence.
I have no further evidence to present. In terms of the evidence submitted, obviously the 2 drug tests showing a combination of drug use. And then just to note the discharge letter in which it did indicate that Mr. White was given the opportunity to attend treatment following the positive drug test. And according to that letter, he declined to attend said treatment, at which point the decision was made to go forward with the remand. But other than the evidence submitted, I have nothing further to add.
Okay, Mr. White? It is now yours.
All right, so as for the treatment, I was broken at the time and they were doing landscaping out of town. So I missed the class because it's one day a week. So at the time, with a period of 2 weeks, I missed the time of the class. That's why I couldn't complete the classes. And I told my parole officer in Florida about that.
So you were working out of town doing landscaping work?
Yes, ma'am.
And you're saying that the classes are only one time a week?
Yes, ma'am.
Anything further?
And as for my mistake, I'm truly sorry for my mistake. I was going through a rough time in my life. As for I lost my grandmother and my cousin, so that was a rough pass, and I was going through it. And I work Monday to Friday all the time. I got my own business on the side, Saturday and Sunday power washing. Please give me another chance to prove myself as for a father and a husband.
Phil, was there anything else you would like to state?
Not at this time.
Okay. Anything further before I announce my findings, Mr. White?
Oh, no, ma'am.
On charge 1, obedience to the law, I make a finding based on state's exhibits A, E, G, H, I, and K through M. On charge 2, drugs, I make a finding based on state's exhibits A, E, G, H, I, and K through M. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. Officer, do you wish to make a statement regarding Mr. White's background and history at this time?
No, not at this time. I think the report pretty much outlined his time.
Okay.
I will state that during the extradition back to Connecticut, his behavior was excellent. There was no concerns. He did comply with everything on the way back, so there was no issues there whatsoever.
And Mr. White, what will be your release plan? What in your relapse prevention plan?
I'll do anything. I'll do a program if I have to, and I was gonna go back to my family.
So upon parole reinstatement, where do you plan on residing?
Florida. That's where I live at.
So being that you were remanded back to Connecticut, you would have to remain in Connecticut for at least 3 months. So
I'll do
you have a sponsor in Connecticut or a halfway house?
We got halfway house in Waterbury.
So your plan is to do programming and reside in a halfway house in Waterbury. Anything further upon parole reinstatement?
Whatever I have to do to release God, I'll do anything.
Officer, anything else you'd like to add before I announce my recommendation?
Connecticut is amenable to his release plan. You know, he was doing fairly well down in Florida, so Connecticut does not object to his return to Florida at this time. However, in light of the substance use and the lack of treatment down in Florida, we would like to see a period of time off in Connecticut in compliance with treatment, at which time we would reevaluate for the transfer down to Florida. And then obviously, just Mr. White for the transfer, both Florida and Connecticut have to agree. So I will put on the record at this point that Connecticut does not at this time see any issues with a transfer application. Again, once he's in compliance with treatment for a while, but ultimately the decision does reside with Florida if they're willing to re-accept him. But no objections to his release plan as it stands at this point.
And Mr. White, anything further before I make my recommendation?
No, ma'am.
I recommend revoke and reparole on October 10th, 2024, which is an approximate 3-month sanction from the date of remand in the state of Florida. I recommend the following conditions: no consumption of alcohol, no contact with co-defendants Tiffany Broderick and Carolyn Splitzer, and a halfway house placement. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 10th, 2024. The board may let my recommended sanction stand or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written documentation outlining the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. So, Mr. White, on October 10th, the board is going to review your case. My recommendation is for your parole to be reinstated on the 10th, but the board has the final decision. So on that day, your case is going to be reviewed, and they're either going to agree with my recommendation or they can exceed my recommendation. And again, if they exceed my recommendation, then another hearing will be taking place.
Okay.
All right, but you'll receive your information on the 10th, on October 10th.
All right. And do I receive that in the legal mail or?
So if the board agrees to October 10th, you're going to be reinstated that day. So you would know that day.
All right. I appreciate it.
Okay.
All right.
Any other questions?
No, I thank you for everything too.
Okay. All right. Thank you. You're all set.
All right. Have a good one.
All right, Mr. Humes, I'm going to contact your PO just to make sure he's available.
Okay,
Okay, P.O. Kwasnick, I'm going to get started. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Parole. This is a revocation hearing concerning A.M.Humes, 347-303. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Edward M. Humes III, and my inmate number is 347-303.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti, as well as P.O. Kwasnick.
Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit.
Parole Officer Dennis Kwasnick, DOC, Parole and Community Services.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony in today's hearing will be taken under oath. Mr. Humes and P.O. Kwasnick, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes,
I
ma'am.
do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges or violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Kwasnick, starting with charge 1, reporting.
Give me a second. I'm still trying to pull up his PVR. I'm there.
Okay.
All right, reporting. On November 6, 2023, you were instructed to report to the Torrington Police Station. On November 20, 2023 at 9:30 a.m., you were also sent a text message as a reminder. However, you failed to report as instructed and later claimed that you forgot. On November 21st, 2023, you were then instructed to report to the Waterbury Parole Office on November 22nd, 2023 at 12 p.m. After we reestablished contact, we arranged for you to meet at the Torrington Police Department on November 22nd, 2023 at 3 p.m. Again, you failed to report as instructed. You called me stating you forgot and you were on your way, but you never arrived. Since then, you have failed to communicate or report as instructed.
Charge 2, program participation.
On November 1st, 2023, you were instructed to participate in both a substance abuse and a mental health evaluation at a provider of your choice. This instruction was further emphasized with you when you signed a misconduct on November 6, 2023, specifically requiring the participation in these program evaluations. For both evaluations, you informed me that you had chosen McCall treatment in Torrington and scheduled an intake appointment for 2 p.m. on November 20th, 2023. You even confirmed this appointment via text message on November 20th, 2023. However, upon contacting McCall treatment on November 20th at approximately 5 p.m., I was informed that you had failed to show up for both the substance abuse and the mental health intake appointments. Additionally, on November 21st, 2023, you were instructed to report to the Torrington Police Department for an intake with the inpatient program. You also failed to attend this required appointment.
Charge 3, residents.
On October 26, 2023, you were accepted into the REACH program and assigned a residence at 438 High Street, Torrington, Connecticut. As you failed to report as instructed, home visits were subsequently conducted in an attempt to locate you. I left notes on your bed with your assigned apartment on November 27th, 28th, and December 1st, requesting immediate contact. During a home visit on December 1st, 2023, the notes were removed from your bed and your belongings were found packed in a black garbage bags. Another note was left urging you to contact me. A subsequent home visit on December 4th, 2023 revealed the removal of the message as well, along with the disappearance of most of your belongings from the apartment. Final message was left on December 7th, 2023, reiterating the request for contact. With no response received and your belongings removed, it became clear that you had chosen to leave the REACH program without authorization and no longer intended to reside at the assigned address. Consequently, on December 8th, 2023, you were officially removed from the REACH program.
Charge 4, absconder.
On November 6, 2023, Mr. Humes was instructed to report to the Torrington Police Station on November 20th, 2023 at 9:30 a.m. The instruction was given both verbally and in writing via text message reminder. However, Mr. Humes failed to report as instructed and claimed he forgot. On November 21st, Humes then instructed to report to the Waterbury Parole Office on November 22nd, 2023 at 12 p.m. After reestablishing contact, a further arrangement was made for Humes to meet me at the Torrington Police Department on November 22nd, 2023 at 3 p.m. Again, Mr. Humes failed to report as instructed. We spoke on the phone. He stated he forgot and was on his way. I offered to meet him at his residence or in the community, but he said he was almost at the police station. I waited for approximately 2 hours after this scheduled reporting time, but he never arrived. Since November 22nd, 2023, Mr. Humes has failed to communicate or report as instructed. Despite multiple attempts to contact him, his whereabouts remain unknown and he cannot be located. It is evident that Mr. Humes does not plan to report to parole or contact parole ever again, nor not does he plan to comply with conditions ever again.
Charge 5, obedience to the law.
On 2/22/24 vehicle in North Canaan and were driving erratically. You struck another vehicle while driving and caused some damage. After this, you barged into a stranger's house. At no time were you invited or given permission to enter the residence. You also led police on a foot pursuit to locate you. Subsequently, you were found and taken into custody. Due to your behavior, you have been charged with the following: larceny of a motor vehicle, 53A-119C, failure to follow a reasonable distance apart, 14-20 or 240 subsection B, and 2 counts of evading responsibility, 14-222.
Charge 6, drugs.
On November 30th, 2023, you used cocaine. On November 6, 2023, you provided a urine sample for a drug screening. The initial test screened positive for cocaine, but you denied using the substance and requested further lab confirmation. On November 26, 2023, Biotech Labs confirmed the presence of cocaine in your urine sample, indicating use. On November 20th, 2023, you sent a text message admitting drug use since November 6, 2023.
Charge 7, mental health evaluation and treatment deemed necessary.
On November 1st, 2023, you were directed to undergo a mental health evaluation at a provider of your choice. You confirmed this directive, signing a misconduct report on November 6th, which explicitly required a mental health evaluation. You informed me that you selected McCall Treatment in Torrington as your provider and scheduled an intake appointment for 2 p.m. on November 20th. During this process, you were provided with the necessary information regarding McCall's location. On November 20th, 2023, you texted me confirming that you were attending your intake appointment at McCall at 2 p.m. However, when I contacted McCall Treatment at approximately 5 p.m. the same day, I was informed that you had not showed up for your scheduled appointment and were a no-call, no-show.
The state has filed the following exhibits, starting with Exhibit A.
Exhibit A, signed conditions of parole. Exhibit B, remand to custody order. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, prior parole violation reports. Exhibit F, signed misconduct. Exhibit G, premier biotech lab report. Exhibit H, screenshots of my text messages with Humes. Exhibit I, pictures of Humes' room at the Reach Department. Exhibit J, the Reach discharge report. Exhibit K, police report case numbers 24000718868, 240007185 and 240007183.
The state also found an addendum to Exhibit C, which states on August 20th, 2024, Mr. Humes was found guilty of assault third and sentenced to 11 months jail, execution suspended after 3 months, under docket number ending in 759. The protective order on this docket was terminated and the 2 counts of breach of peace were nollied. He was also found guilty of evading responsibility and sentenced to 11 months jail, execution suspended after 3 months, under docket ending in 368. The charge of following too closely was nollied. The charge of larceny of a motor vehicle first, under docket ending in 671, was nollied. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, I have.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and at this time, it is the state's opportunity to present any evidence and speak to any of the evidence submitted.
I believe the violation report speaks for itself. I've worked with Mr. Humes a couple of times, and unfortunately, both times resulted in his reincarceration. This is his second time that he absconded from parole. He usually vanishes for months. The last time he vanished, we had to extradite him back to Connecticut from New York. When I had him for briefly in the community, he was basically riddled with non-compliance and continued drug use. He refused to participate in programs, and him only reporting once is directed while he was at the REACH program. I've tried to reach out to him. I tried to provide substance abuse treatment to him. I even tried to place him in the App Foundation inpatient program. He refused all those opportunities. His pattern of numerous missed reporting dates, drug use, new criminal behavior over the past 2 years is evidenced by the violations and the 12 misconducts that I have issued him. Efforts to address his substance abuse through 3 inpatient stays at the App Foundation since July 2021 have proved insufficient. He has a high actual risk, according to scores, for his repeated violations, coupled with his absconding and criminal activity. Paint a clear picture. He's a threat to himself and to the community. When I wrote this violation report, when he was an absconder and we were looking for him, he did actually commit new crimes, which is evidenced in the parole violation report. From my understanding, he stole a vehicle. He drove to a stranger's house, barged in, and then was, when the state police were called for this, I guess you would call it a home invasion, he kicked down or went into the house with the homeowner there who was scared. The state police were called. They took him on a foot pursuit. They had a drone. They were looking for him for hours. I guess he avoided the drone because he hid in a pile of manure. And when they subsequently located him, they charged him with all the crimes. I guess he received a sentence for 3 months. So, I mean, it goes beyond the typical drug use. The drug use is now fueled with more criminal activity and more victims. I did recommend that he have at least 6 months community supervision before he completes a sentence. I'm changing that to a recommendation of no new hearing date and that his discretionary parole should be maxed out.
It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes, good morning. Regarding charge 1, I've got no comment. As to program participation, I have no comment. Residence, I don't believe there's any evidence regarding charge 3 that he changed his residence or had a permanent intention of changing his residence. There's no new residence. All there were some belongings missing. We don't know if that is a majority of his belongings. We don't know if he ever got those notes. We don't know who moved those notes, if they were ever received. No comment as to absconder. As to obey the law, in the addendum, the sentences that are listed are not possible sentences. You can't receive a suspended portion and then a jail portion and a split sentence. There's no probationary period listed whatsoever. So I ask that no finding be made as to obey the law, even for the two crimes, assault, third, and evading, that he allegedly pled guilty to and got what appears to be suspended time, then jail time with no period of either probation or supervision or anything that's listed. It's the state's burden of proving that. He was never charged with home invasion. He was never charged with burglary. He was never charged with criminal trespass, and he certainly wasn't convicted of any of those crimes. He was merely received a 3-month sentence with some suspended time and no period of supervision proven for an evading responsibility misdemeanor and assault third misdemeanor. There's no allegations that there are any injuries to any parties. As to charge 6, I don't believe it meets the preponderance standard as to the first positive cocaine urine, because he hadn't signed his conditions until November the 6th. Exhibit A states that. So any conduct that occurred on 10/30/2023 is outside that parameter. That 11/6 positive would have been the first positive, and I believe it's listed as an initial intake positive. No comment as to mental health evaluation and treatment. Thank you. That's my comment as to the preponderance standard.
Kwasnick, would you like to make a closing statement before I announce my findings?
I'm just looking to see when he actually signed his parole agreement. I have 8/18/2022.
That's not submitted as evidence. It's only Exhibit A, which was submitted. That's 11/6/23.
Let me go into my evidence. I'm sorry, just trying to pull this up here.
No problem.
So just, for the record, when they come out, we have them sign conditions. His conditions were signed on, I think I said 8, let me get that, 8/18/2022. When he came out to me with reach and what I submitted for evidence are when I actually go over the conditions again. So these conditions were explained to Mr. Humes twice, which he initialed and signed on both dates.
Just would clearly object to any conversation or any statement about any earlier date because it's not in evidence. Any testimony is in evidence. It would have to be in the exhibit. There's no exhibit showing that. Thank you.
Kwasnick, anything further?
Nope.
Right, and counsel, anything further before I announce my findings?
Not regarding the preponderance of the evidence standard. No, thank you.
Okay, I'm just going to take a quick recess based off of the information provided.
It's not muted.
Oh, I know. I was just looking to see who was in, like, watching on the side. It's like the whole list of people that are watching.
Right. It's open to the public, sir.
I just can't see that from here because I don't have any glasses. I haven't had any since I've been back here. I lost them the night I got rearrested and can't really see at all.
Okay, we are now back on record. On charge 1, reporting, I make a finding based on state's exhibits A, C, and H. On charge 2, program participation, I make a finding based on state's exhibits A, C, F, H, and J. On charge 3, residence, I make a finding based on state's exhibits A, C, and J. On charge 4, absconder, I make a finding based on state's exhibits A, C, and H. On charge 5, obedience to the law, I make a no finding on the charge following too closely as this charge is an infraction. I make a finding on the rest of the charges based on Mr. Humes' conviction as well as state's exhibits A, C, and K. On charge 6, drugs, I make a no finding on part 3 as the state failed to provide sufficient evidence to prove Mr. Humes' action meets the elements of this charge. I make a finding on the rest of the parts in this charge based on state's exhibits A, C, F, and E, or A, C, F, and G. On charge 7, mental health evaluation and treatment deemed necessary, I make a finding based on state's exhibits A, C, F, and H. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. P.O. Kwasnick, do you wish to make a statement regarding Mr. Humes' background and history at this time?
No, just that what was provided by the defense that I got at 2 p.m. yesterday, like, I'm not aware of any of, like, going to AA. That was news to me. I'm sorry, pull up this email. And I got it late, yesterday evening. I didn't have a chance to can the defense make a statement before I just review this one last time?
Okay, counsel, do you wish to make a statement regarding Mr. Humes' background and history?
Certainly. My client is a single 46-year-old male. He receives his primary support from his fiancée, Alyssa Calder, sober network out of Torrington, and his new boss and boss's wife, Paul and Jackie DeMaria. He received his GED while incarcerated in 2010. He's taken courses in general studies towards an associate's degree at Robinson Correctional Institution and maintained a 4.0 grade point average. He is a contractor by trade. Back in 2023, he was working full-time for Kelly Green Products for approximately 3 months. He does side jobs, including painting. They're holding a job for him with Paul DeMaria in Torrington. We have his telephone number. He has a full-time painting opportunity with Paul DeMaria. He wishes to be placed in a halfway house in Waterbury and or a sober house eventually in Torrington at New Horizons or Hollister House. His fiance has attempted contact with Hollister House, trying to get him there. He wishes to work with he works with the mental health unit, is medication compliant while incarcerated. He successfully completed voices. While incarcerated, he applied for other programming, including Tier 2. He's on the waiting list for Tier 2. He volunteered one afternoon at a soup kitchen in Torrington. He attends AA and NA meetings weekly. He is amenable to treatment at McCall's once he gets set up there. I understand it's alleged he didn't report for 2 intake meetings, but that doesn't mean that he's not willing and able in the future to report. The recommendation originally was for 9 months. He's been incarcerated now since 2/22/24, approximately 8 months. I don't see any additional reason to revoke his parole. As I stated earlier, we still don't know the sentence that he was sentenced to. It has not been put into evidence whatsoever. It's only for 3 months that he received for each of the 2 misdemeanors. This is misdemeanor sentence. We have a couple of positive hearings. We have a very short period of absconding. I don't see any reason why or reason necessarily produced as to why he should be held any more than he's already been held. I can't think of any reason other than punitive, purely punitive, to make him sit in jail for the remainder of his sentence. At some point in time, the PO thought that it would be beneficial for him to have 6 months of supervision, knowing full well all of the allegations at the end of the report when he signed it. There's been no substantial change in circumstances since that time, and so we'd ask that he be released on that 10/10 date, the next day that the board is going to be meeting with approximately an 8-month sanction. Thank you for your time and consideration.
P.M. Kwasnick.
Thanks. No, I pulled it up. I just want to put on the record that what the defense has submitted in terms of his parole accomplishments, none of it is verified. As for having employment lined up, he wasn't working when he was with me. As for going to AA and substance abuse treatment when he was out with me, that's news to me. He had provided no evidence that he was attending AA. He wouldn't go to McCall's when I made referrals over there. He wouldn't go to the App Foundation when I made referrals over there. Volunteering at a soup kitchen, again, news to me, unverified, no idea what he's talking about. He's never mentioned to me that he's volunteered at soup kitchens or provided proof that he has. Future plans, I wish him the best. I hope he does enroll in traffic training school, and I hope he does get the substance abuse treatment that he needs. And then again, just my initial recommendation, Mr. Humes is a bad addict. I don't believe that addicts deserve to be in jail. They need treatment. However, his actions of absconding now twice, his actions of not going to any treatment that parole has provided opportunities for, and now has been before or after I wrote this report and signed the report, I didn't know that he would commit new crimes, stealing somebody's car, bursting into somebody's house while they were playing video games, and scaring the homeowner who did not want to press charges because he felt bad for Mr. Humes, and engaging the state police in foot pursuits and had to be apprehended. So he has, because he was left out there, he has created new victims. If he is released, he will create additional victims. Basically, the risk instrument puts him at a high risk for recidivism. So at this time, unfortunately, I would recommend that he be denied parole or revoked parole with no new hearing date.
Counsel, anything further?
Yeah, just briefly. My client wasn't charged with burglary. My client didn't plead guilty to burglary or entering anyone's house or terrorizing anyone. He wasn't even charged with stealing a car. We're talking about 2 3-month sentences to 2 misdemeanors. He will be supervised by probation. We are going to assume, because he received a split sentence, once his sentence is over. If he is such a bad addict, we only have a couple of positives for cocaine here. We don't have any, this is not a violent conviction. There's no serious violence here. There's no listing of anyone being injured here. One of the convictions is for an assault in the 3rd degree, but he received 3 months. So none of this is heinous. Certainly, everyone deserves an opportunity at treatment. It's not like you have a limited number of opportunities here. And so even with the convictions, if that's the only thing that's changed, although the crimes are listed and are listed as more serious than it actually turned out to be, when this was signed on 12/13/23, I just don't see any substantial change in circumstances from the 9-month. What has changed? Nothing has changed, and I don't see any substantial change in circumstances that should call for the revocation of his parole. Thank you for your time and consideration.
P.M. Kwasnick, anything further?
No, I'm all set.
Attorney Famiglietti, nothing further?
No, thank you very much for your time.
I recommend a revoke with no new reparole date, which is an approximate 15-month sanction. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: no consumption of alcohol, general no contact with Christine Sheldon and Michaela Ware, halfway house placement, mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 10th, 2024. The board may lessen my recommendation or let my recommendation stand. Okay, so this does conclude the revocation hearing. You're
We'll
muted.
meet- Thank you. The board's going to meet on the 10th, sir. Call me on the 11th to see if they shortened. They have the capability of shortening your sanction. Okay, so call me on the 11th. I'll let you know what the board decided. Okay.
Okay, thank you.
Have a great day, sir. Good talking with you.
You too.
Hey,
Thank you.
regardless what happens, good luck to you. Make some better decisions in the future so you're not back in front of me under these situations again. All right.
Thanks, Dennis. Sorry about that.
All right, Ed. Take care.
All right,
Thank you.
I'm all set. All
Yes, you're all set. Thank you.
right,
Yes,
thank
sir.
you.
You're all set.
Good morning.
Hey, how you guys doing? Where'd you go?
If we can get started with Morales, that would be great if he's available.
I don't have a Morales. Give me 1 second. Hang on. Yeah, I don't have a Morales for you guys. I have a Napiello.
Sorry about that. So I called too early. I'm supposed to be calling Hartford. I'll call back later.
No problem.
Sorry about that. Good morning.
Good morning. How are you?
Good. Who do we have in the seat?
I have Mr. Camacho.
Oh, this is Mr. Camacho. Okay.
I have two more. Do you want someone else first?
Well, let me see if his attorney is available as well as yeah, let me see if his attorney is available.
Copy that. Okay.
Thank you.
You're welcome.
Yeah, you said that's why she probably turned it off. Because she thought it was messed up. No, they can still hear us.
Well, that's as long as you're good. Yeah.
This is new to all this.
Hmm?
This is new to me. Been special parole for 4.5 years. You know, first time.
A lot of stuff is different with like COVID
Yeah.
technologies. Using a lot more.
I used to see you in person.
So we'll get started with Mr. Camacho and then we'll go to Mr. Morales next.
Copy. Okay.
Thank you. Mr. Camacho, we'll get started as soon as we have your attorney on the line.
Okay.
This is Mr. Camacho.
Okay. Yeah,
Ms. Saunders going to be there next.
okay, Ruth,
Yes.
the last hearing, Trisell, I didn't do that hearing yet because she's still on Mr. Kane. So I just left when I saw the message. So I'll just stay here.
All right, I'll let you know when she's ready for you. I'll let her know that you're with Ms. Saunders.
Yeah.
Thank you.
Thank you.
Attorney Joe, this is Mr. Camacho we
Yes.
have received.
Yes.
So P.O. Barnes wants to participate in for Morales, and I haven't received confirmation that he's ready. So I figured we'll just start with Mr. Camacho.
I'm sorry, P.O. who?
Brian for Mr.
Oh,
Gonzalez.
David Byrne? Okay.
Byrne, yeah. So he wants to participate for Morales, and he said he was running a little behind. So I figured we'll just get started with Mr. Camacho.
I thought Mr. Morales was supposed to be at 12:15.
Nope, because he's here. I have him at 10 a.m.
Oh, Morales?
Yep,
Oh, okay. I didn't even realize that. Okay, thank you.
no problem. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Alexander Camacho, 314-162. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Hartford Correctional Institution. Please state your full name and DOC inmate number for the record.
Alexander Camacho, inmate number 314162.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Camacho.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Camacho, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
I do.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On April 8th, 2024, New London Police received a call that you jumped over the counter of the CVS pharmacy located at 817 Bank Street, New London, and were restrained by employees. Upon police arrival, you were placed in handcuffs and taken into custody. You reported to police people were after you, but you could not provide any further information regarding who. Pharmacy staff reported you pushed your way into the pharmacy and grabbed an employee. Police reviewed the pharmacy's video surveillance and observed you attempting to open the pharmacy door several times. As a pharmacy employee was leaving, you entered the pharmacy and grabbed a female employee from behind, dragging her backwards to the rear of the pharmacy. Police then observed another employee grab you in an attempt to have you release the female victim. While being transported to a local area hospital, you admitted to police you had been smoking crack cocaine for 3 days prior to the incident. Subsequently, you were arrested and charged with kidnapping first degree, criminal attempt to commit robbery 3rd degree, and breach of peace 2nd degree. The state has filed the following exhibits. Exhibit A, signed Connecticut Conditions of Parole. Exhibit B, Connecticut Department of Correction Remand to Actual Custody Order. Exhibit C, Notice of Parole Violation. Exhibit D, Parole Violation Report. Exhibit E, New London Police Report, ending in 488. And Exhibit F, Continuous Minimus. The state has filed an addendum to Exhibit D, which states on September 4th, 2024, Mr. Camacho appeared in New London Court GA10 on docket ending in 807. The original charges of kidnapping 1st, criminal attempt at robbery 3rd, and breach of peace 2nd was not prosecuted. Instead, he was sentenced to 6 months jail for unlawful restraint. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed the following exhibits. Exhibit 1, parole accomplishments and future plans for parole reinstatement report. Exhibit 2, letter of supervision from P.O. Deanna Ball. Exhibit 3, letter from Carrie Arteaga, managing partner at Recovery 12 Solutions. And Exhibit 4, transcript from New London Superior Court. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. I believe the addendum is stated accurately. My client did enter into an Alford plea to the charge of unlawful restraint. 2nd, received a 6-month sentence. I believe that sentence is due to expire, and correct me if I'm wrong, on October 4th of 2024.
I have October 6, 2024.
Okay, thank you. Nothing further as to the charges.
On charge 1, obedience to law, I make a finding based on of Mr. Camacho's conviction, as well as states exhibits A, D, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you. My client is 37 years of age. He's single. He does not have any children. He does live with both mental health as well as substance abuse issues. During his time period in the community, he successfully sponsored, he successfully completed the App Foundation, and eventually transitioned to living in a sober house where he remained for approximately 3 years up until he was remanded from custody. He was in the community for over 4 years prior to this violation, and this is his first violation of his parole. He's been in custody now for almost 6 months. As you just indicated, he'll be in custody 6 months as of October 6th of 2024. And again, he was working in the community, attending medication assistant treatment, attending SCAD in New London, where he consistently attended for over 2 years. He was attending group therapy, individual therapy, receiving methadone, and then eventually transitioned to receiving Suboxone. He was, again, living at that sober house. He was in Recovery 12. He remained there until his remand. He was working. He held various employment jobs, working at Burger King, Smash Burger, a roofing company, a construction company. He worked for the Lighthouse Inn. He was a dishwasher. He was working 12-hour days and working, well over 40 hours a week. I submitted the court transcript here just to show that though the charges at first blush appear to be very serious in nature, the state took that into consideration when they reviewed the facts of the case and substituted that information, as you can see, to charging my client with the unlawful restraint in the 2nd degree. My client was doing very well in the community and unfortunately suffered a relapse prior to this incident taking place. You can see the comments of the state's attorney as well as the court that they recognize that this was an issue that completely, came from his came from a relapse and, substance abuse issue, coupled with mental health. The victim's comments were also noted in the transcript where the victim was fully supportive of the court disposition, including the 6-month jail portion of the sentence, but also including the fact that the client would continue to be supervised by parole, would have that structure, would continue in treatment, and was fully supportive of the fact that my client, who was doing so well in the community, was in need of treatment here. So I think that's important to note, when you have an incident like this, that the victim was fully in support of it. And again, as well as the state's attorney's office. And again, if you look at Exhibit 2, which is the letter that his parole officer submitted to the court on his behalf, I think it perfectly outlines all of his successes that he was having in the community. It also, highlights that he was communicating well with his parole officer. When he was having trouble, he communicated that with her, and they seemed to work well together. In the past, when he had issues, she immediately got him into treatment, and he had success with that. He continued to remain in the community successful after that particular incident. And so here you can see that preceding this incident, he also reported to her that he was suffering from some paranoia, and that he eventually admitted that that was substance abuse induced. And it's unfortunate that I think that she was in the process of trying to assist him when this particular incident took place, and obviously he was arrested and then had to be remanded. So I think it's important to note that when he's in the community, he was working well with his parole officer. He was communicating well. I mean, those are the things we like to see from our clients. We like to see them communicating with their parole officers and having that level of success when they are feeling like things are maybe getting overwhelmed and that they're, suffering possible relapses, that they're able to have that line of communication and that it's working. And so I think that's this particular case and this particular parole officer, they did appear to be working well in the community together. And it's just unfortunate that the incident kind of, escalated and he ended up in this situation. I think the court disposition was certainly a fair disposition, taking everything into account. And I would concur with the recommendation here of his parole officer that he be re-released to parole supervision when the court case is completed. And that court case will be completed as of that October 6th date. So we are asking that he be re-paroled into the community in line with of his parole officer, which would be probably the next board review date that's available. When he's re-paroled, he can return to the sober house. And again, you have a letter from the sober house that outlines how successful he was while he was there. He was, I can just have one moment. The letter indicates that he was there for almost 3 years. He successfully passed all urinalysis, breathalyzer tests that were administered randomly. He was continuously employed full-time, a model citizen in their community, that he had grown so much as a human being since the day he arrived. He was attending meetings on a regular basis, complied with all house rules and anything they asked of him. He fulfilled all requirements, was a pleasure to have as a recovery community help member. And he also helped newcomers when they arrived, and is a wonderful human to all of those around him. I mean, I think this speaks volumes to how well he was doing in the community. I did have a conversation with his parole officer, P.O. Ball, prior to this hearing, and she also confirmed that he can return to the sober house. And so I believe she's willing to assist him in that return. And he does have his employment within the construction company to return to, but certainly he has other employment opportunities if for some reason that didn't work out. So again, we are asking that he be re-paroled at the next available date. Thank you.
I'm just going to take a moment before I announce my recommendation.
Yes, thank you.
I recommend a revoke and re-parole on November 8th, 2024, which is an approximate 7-month sanction. Looking at this case as a whole and taking into account Mr. Camacho's mental health and substance abuse and the nature of the crime that was committed, Mr. Camacho was on his 3rd relapse despite having many successes in substance abuse treatment. So my recommendation is a 7th-month sanction with the following conditions: no consumption of alcohol, anger management, no contact with co-defendants Leslie Vasquez, no contact with victim MM and RW, a general no contact with CVS Pharmacy located at 817 Bank Street in New London, halfway house placement, mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 10th, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board chooses to impose a sanction longer than what I have recommended, then a supplemental hearing would be held. Before the hearing, the board will provide you with written notice documenting specific reasons why they might want to exceed my recommendation. So this does conclude your revocation hearing.
I apologize. I missed the board review date.
Oh, 10/10.
10/10. Okay, thank you. Do you understand, Mr. Camacho?
I'm kind of confused. So I'll be released on what date?
November 8th is the recommended reparole date. So it goes to the board on October 10th. As long as they agree with it, you're going to leave on November 8th. Okay, if for some reason they don't agree, they can lessen the sanction or they can ask for a longer sanction, which will be notified of. So if you want to give me a call after the October 10th date, I can tell you if they accepted it.
All right.
Okay?
So October 10th, and what was the other date? October 20, November?
Nope. October 10th is the board review. November 8th is the day you should anticipate leaving.
All right.
Okay?
Done.
All right. Good luck, sir.
All right, no problem.
Thank you.
Mr. Morales next, ma'am.
Yes, please.
Okay.
Let me just have something quick. Good morning.
Good morning.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jonathan Morales, 395-889. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Jonathan Morales, 395-889.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney as well as P.O. Byrne.
Thank you. Attorney Sonia Jones, Public Defender's Office Parole Revocation Unit on behalf of Mr. Morales.
And Parole Officer Burn from the Future Investigation Unit.
This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversary proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony of today's hearing will be taken under oath. Mr. Morales and P.O. Burns, please raise your right hand.
Oh, okay.
Do you solemnly swear or solemnly sincerely affirm that the case may be that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your professor is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and the severity of the allegations. Once the state is finished, your attorney will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based off of the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charge that the state your officer is bringing against you and the information underlying each charge. Charge 1, obedience to law.
On 12/17/2022, you were arrested by the Tuscaloosa County Sheriff's Office and charged with receiving stolen property first degree. You failed to appear or comply with court orders regarding these charges. On 8/22/2024, a warrant was signed in the Circuit Court of Tuscaloosa County charging you with failure to appear or comply with court orders on the charge of receiving stolen property first. Based on your actions, you're in violation of your release condition, obey all laws, obedience to the law.
The state has filed the following exhibits, starting with Exhibit A.
Yeah. So. Yep. The remand to custody order, Exhibit B, parole violation notice, Exhibit C, parole violation report, Exhibit D, signed parole conditions, and Exhibit E, the signed Tuscaloosa County warrant.
Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
And defense has also filed Exhibit 1, Order of Circuit County of Tuscaloosa County of Alabama, or County of Alabama, under case ending in 405, recalling wit on September 13th, 2024. Defense Exhibit 2, warrant issued out of the Circuit Court of Tuscaloosa County, Alabama, under case number ending in 405. Timestamp for recall of writ on 9/15/2024 at 9:24 a.m. And Defense Exhibit 3, letter from Warrant Division, Tuscaloosa County Sheriff's Office confirming withdrawal of warrant. Today we have no witnesses, and at this time it is the state opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations.
Mr. Morales had a parole hearing. I don't recall the date, but earlier in the month of September, when he was reinstated. Upon the reinstatement, I believe he was at McDougal Walker Correctional Institution. At the time they were doing the paperwork to file the release, it popped up that he had a fully extraditable warrant at the time out of Tuscaloosa County. So a remand to custody order was lodged at that point. That's why we're here.
Okay. It is now the defense opportunity to respond and make a short statement and testify with respect to probable cause and the severity of the allegations.
Thank you. We would submit that there should not be a finding of probable cause here based on the fact that my client has been in custody since December 17th of 2022, continuously held. He did have a matter pending in Alabama, and he did resolve that matter. There was a condition ordered by the court that he report to probation upon his departure from DOC. However, he did have a detainer out of the state of Virginia, and he was released to that detainer. He did go to Virginia. He served a sentence in Virginia, and unfortunately, when he did not report to probation, a warrant for failure to appear issued. There was some disconnect with the clerk's office in Alabama, not realizing that he had been released to a detainer in Virginia. He was then brought back to Alabama on that warrant, and Connecticut did come in to pick him up. I believe it was September 9th that Connecticut came to pick him up. And right after that, the issue was resolved through the clerk's office. The court ordered that the warrant be vacated based upon the fact that he was in custody in Virginia. And they did issue that order. The clerk's office entered the order in. There is no pending warrant. The warrant is as if it never existed, because he did not actually willfully fail to appear for probation. So we would be asking that there be no finding of probable cause and that he be reinstated to parole today.
Okay, just to confirm, so he was supposed to report to probation upon being released
from custody in Alabama.
But then he was detained and remained detained and went to Virginia because he had pending matters there. So he never actually left custody?
Correct. He has been held in custody, and perhaps P.O. Byrne can confirm this as well, since December 17th of 2022.
Yes, but he did return to Connecticut. I believe it was in May, May
Right, and
25th, I believe is when he returned to Connecticut.
I did learn that when I talked to P.O. Waldron, he did inform me about the issue with McDougal notifying that there was the warrant. So yes, it's my understanding that he came back, but in the interim is when the warrant was vacated.
Can I say
Or
something,
recalled.
please? Because the dates are getting confused. I've been in custody since December 17th of 2022 when I got arrested in Alabama. From there, I went to Virginia. And then from Virginia, I had to go back to Alabama to sign my probation papers because they extradited me without me signing my papers. So I went back to Alabama on May 23rd, 2024. Parole extradition unit came to get me in Alabama, and I was held in custody here. My original parole hearing was on August 20th, but Alabama had thought I got released that day, but I didn't. That's why they filed the warrant on August 27th. But I've been continued held since December 2022. So when my parole officer had called down there, they vacated the warrant because they thought Connecticut had released me, but I have not been released since the last 2 years. So that was the timeline was a little confused.
Yep.
Anything further, counsel?
No, I think the documentation that I submitted is very clear as to exactly what happened here. It shows the timeline of the order being the court's order, the clerk's office date stamping that it was recalled. It's indicated right in the paperwork. And then we confirmed it just to be 100% certain through the sheriff's office that they were not holding any warrant for Mr. Moralez.
P.O. Burns, anything further?
No, do you have the documentation for them? Just I may need that later.
I did, P.O. Burn, I did send you a copy of it, but you were out of the office. So that's why I ended up talking to I think P.O. Waldron, and I sent him a copy as well, because I just wanted to make sure you guys did receive it.
Okay.
I'm just going to take a quick recess before I announce my findings. Okay, we are now back on record.
If I could just make one last comment, just to make sure this is perfectly clear. If you look at the Exhibit E that was submitted by the state, it does, it's the warrant, a copy of the warrant, which indicates you are hereby commanded to arrest Jonathan Moralez at the very top of that warrant. And if you look at Defense Exhibit 2, you'll see at the very top of that, it says the warrant issued in this case should be returned without action, and that's the September 13th, 2024 date. I just want to make sure it's clear.
Anything?
No.
Further? Okay. On charge 1, obedience to law, I make a no finding of probable cause as the state failed to provide sufficient evidence to prove Mr. Moralez actually meets the elements of this charge. Because there is no probable cause to believe you committed a violation, your parole will be reinstated. The records office at this facility, as well as your parole officer, will be notified as he is here today. So I'm going to be sending all this information over to the facility that you're at. And as of today, you should be reinstated. Your parole should be reinstated. Before I conclude the hearing, what is your release plan? Like, where do you plan? Like, what's your plan? Do you have a sponsor, halfway house?
Originally my parole said halfway house with a GPS monitor. So I think they're just gonna put the GPS in the halfway house.
Yes. Okay, what
Did you have a
location?
specific area?
I was trying to go to like Hartford or like Norwich areas, closest to Norwich I can possibly go.
Okay. I think P.O. Byrne has some information.
Yeah, that's when I spoke with you at HCC a few weeks ago, when we signed the notice, at that time you said Bridgeport. So I processed the paperwork for Bridgeport. So that's where you're going to be going.
All right, yeah, because when my PO came to get me, they said Bridgeport, but that's because at that time they didn't think I was going to get reinstated and everything happened the last minute. I'm my grandmother's caretaker, so I was trying to get as close to Norwich as possible.
Said, I mean, as we spoke, when you said Bridgeport, that's what I went with. So that's what they. I'm going to be. I will be picking you up today, and you will be going to Bridgeport.
That's perfectly fine. Thank you.
And we'll talk. We'll talk when I get to Hartford. I have some paperwork for you to sign and stuff.
All right, Burn.
All right, that concludes the preliminary hearing. Thank you.
Thank you.
Thank you, everyone. Thank you, P.O. Byrne.
Thank you.
Have a good one, Miss Jones.
You too. Good luck.
Miss Jones, Trucello is ready for you with New Haven.
Okay, I have one more case here. What would you? That one's.
She has Attorney Dean as well.
What would you like? What would you like me to do? It's a prelim, and it would probably be pretty quick, but
With Miss Saunders, you have a prelim?
No, with Trucello. So do you want me to finish here? I don't know.
I don't see you with Saunders until 11:30.
Okay, I guess I have an old docket because I had A.M.Marino at 10.
Yeah,
no?
you have the older docket.
Okay, so A.M.Marino is now at what time?
11:30.
Okay, thank you.
Mm-hmm.
Give me a second.
Yeah.
Am I gonna be able to hear this?
Yeah. Hi, Matthewson.
This is not my case, so I'm going to disconnect, so someone else should be calling.
My apologies. My apologies.
No worries, you're good.
Okay. Visits are mine. Say that again?
Officer Saunders, Attorney Dean is here. Whenever you're ready for Attorney Dean.
Okay, I'm going to see who is available. I'm calling the facility right now.
Thank you. All right.
Hello,
Hi, good morning.
good morning. Who would you like first?
If we could start with Neiman Smith.
Neiman
Ortiz.
Smith?
Yep.
I will bring him in. I believe it's Burl.
Hi, good morning.
Good morning.
Hi, this is for your preliminary hearing. I'm going to get your attorney so we can get started.
Okay.
Thank you. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Marion Nesmith-Ortiz, 439-167. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video of the Board of Pardons and Parole Central Office and McDougal Correctional Institution. Please state your full name and DOC inmate number for the record.
Marion Nesmith-Ortiz, 439167.
This is a public hearing. Public access to this hearing is available via video live stream. Also, I have Attorney Dean here who would like to speak with you.
Yes, for the record, Hannah Dean on behalf of Mr. Nesmith-Ortiz. Sir, I had tried doing a legal call with you yesterday at the facility, but I think there was an issue with being able to come down or something.
Yes.
So today for this hearing, if you want me to represent you, I would need a continuance in order to speak with you and go from there. However, if you don't want that and you want to go ahead and proceed today, you can. I would just suggest that you not say anything about the criminal case that you have, because this is all being recorded and what you say here could potentially impact you in that case, okay?
How would you like to proceed?
I'll continue it with the attorney.
Okay, so my next hearing would be October 15th. So that's when you will come back before us. And in the interim, you'll be able to speak with your attorney.
Yes, I will email the facility this afternoon and see if I can get you on the phone either today or tomorrow.
Okay, thank you.
Okay, thank you. So your hearing is officially continued until October 15th, 2024.
Okay, thank you.
Thank you. Thank you. Speak soon.
All right.
Hello, are you guys ready for Mr. Lloyd?
Yes, we are.
Fantastic. Lloyd, you're up.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Lloyd, 320002. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons Parole Central Office and McDougal Correctional Institution. Please state your full name and DOC inmate number for the record.
Ron Lloyd, inmate number 320002.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Lloyd, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. Good job. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you would have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Do I get to talk, like,
Yeah,
do I get to tell my side?
Absolutely, if you choose to do so. Right now, I'm just going over your rights with you and informing you of the procedure. So we're going to get there where you'll have an opportunity to testify. Okay.
Okay.
So you do have important rights at this hearing, which I now will review with you. But so far, do you understand the purpose and procedure before we proceed?
Yes.
Okay. So you have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or do you want to proceed without counsel?
I want to proceed without counsel.
So you have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
So we now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. On charge 1, reporting. On July 31st, 2024, you were directed to report to the Norwich District Office on August 1st, 2024 at 10:30 a.m. You responded to your supervising officer's text message acknowledging your report date of August 1st, 2024. You failed to report as instructed. On August 1st, 2024, you were again directed to report to the Norwich District Office, to which you informed your supervising officer you would not be reporting as instructed. Charge 2, GPS. On July 8th, 2024, you failed to properly charge your GPS monitor as instructed, allowing it to shut down. On August 1st, 2024, you removed your GPS unit without the express permission of your parole officer. Charge 3, curfew. You failed to return to your approved parole residence by your 8 p.m. curfew on the following dates: July 26, 2024 and July 30th, 2024. On charge 4, residence. On August 1st, 2024, a home visit was conducted at your only approved parole residence of 40 Hamilton Avenue in Norwich. All of your personal possessions were removed from the residence. And on charge 5, absconder, on August 1st, 2024, you failed to report as instructed. You removed your GPS monitoring device and all of your personal possessions were removed from your only parole approved residence. You sent your supervising officer a text message stating, "I'm going to be honest with you, I'm not coming." To date, your whereabouts in the community have been unknown since August 1st, 2024. The state has filed the following exhibits. Exhibit A, signed Connecticut Conditions of Parole. Exhibit B, Connecticut Department of Correction Remand to Actual Custody Order. Exhibit C, Notice of Parole Violation. Exhibit D, Parole Violation Report. Exhibit E, Allied GPS Monitoring Event Summary Report. Exhibit F, GPS Monitoring Agreement. Exhibit G, Decision Information Summary and Update. And Exhibit H, text messages from 860-294-3075. Mr. Lloyd, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes? The evidence packet, did you receive it?
No, I was received on the day my PO came in and gave me my violations. She gave me everything you read about when I had told my PO I'm being honest, I'm not coming in. That's like the most I have got. I ain't gotten nothing else besides that package that read like the curfew and stuff like that.
Yeah, so everything I just read was received in your packet.
Oh, yeah, I got that right there.
Yeah, that's what I'm asking. You received all of that.
Yes.
Okay. So today we have no witnesses. And it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify?
Yes.
Okay, it is now your time to do so.
How you doing how you doing?
Great. Thank you for asking.
I just want to say, I know it's a bad look because I had just came home June 14th off of 5 years. I'm a 4-year sentence. It was 4 years, and I was in the community for a month, and like a week and some change. I didn't really get to do much, and I am taking full responsibility for cutting the violation, but everything was going great until that one moment. I'm not gonna lie, I had missed my curfew twice, and my PO had told me if I missed it again, she was gonna violate me. I was home for such a short time that the third time that when I was in Hartford, from Hartford to Norwich is a very long ride. So I got caught up in traffic twice going to see my daughter. And I'm not gonna lie, man, I kind of panicked the third time, like when my braces started acting up. I knew I was gonna miss curfew. I kind of panicked. And that's when I told my PO, I was like, I'm not gonna lie, I'm gonna be honest, because I didn't send that text in like a disrespectful manner. I sent it letting her know, like, I'm not gonna lie, like, I'm gonna be honest, I'm not gonna show up, because I thought she was gonna violate me. But when I did run, I was gonna turn myself in on that Monday, and I got back on that Thursday. I was just gonna spend the weekend out and just turn myself in, because I didn't want to run. I didn't want to run. Like, I was like, I hate being on the run. Like, it's whack. Feel me? Like, I don't want them kicking in my mother, my sister, and my people's doors, looking for me putting up them at risk. So I was gonna turn myself in. I'm not gonna lie to you, because, like I said, I don't like being on the run, and I kind of panicked a little bit. I'm not gonna lie to you, man. I understand that you're gonna give me my sanctions, but I've been already down at least 50 cents. Hey, I know I gotta pay for what I did, but I just came home. Like I said, I was only home for like a month and a little bit. I was doing good until I panicked and thought she was gonna violate me for me being late on my third curfew. I kind of panicked a little bit, and I took responsibility. And I've been through 3 facilities on this journey. I just came out of BOS yesterday, like from the mental health infirmary. I've been through hell on this journey. Like, I've been through some stuff with Hartford PD. Feel me? They know what's going on. And every time I come to jail, I gotta pay the consequences for something I did with Hartford courts. And every time I come in DOC, I gotta pay the consequences, and I gotta be running all over the place because of my cooperation for something I did that helped the community. And I would ask you, man, that's why they had me in Norwich, all the way out there away. But I would ask you if you could please, like, the shortest sanctions for me, because I know I messed up and I do own responsibility, but I've been already about to be 60 days. Could you please at least, because I don't want to keep going through this. I'm trying to get back, put on my medication, and DOC giving me a hard time because on special parole said I need mental health evaluation. And I used to take medication and I came off of it because I felt like the dose was too high. But I'm trying to get put back on my medication right now. I'm just looking for a little bit of help. And me being in jail for 90 days, another month, another 2 months, I don't feel like that's gonna help anything. I just feel like when I come home, I really need mental health evaluation to get put back on my medication. But I do take responsibility for panicking and running. And I promise you, if you give me another chance today, right now, even if you put me in a halfway house with immediate release, I'm not gonna do nothing to mess it up. Cause I was only home for a month and like a week, man. For 4 years, I didn't ever really get to eat a good plate of oxtails or curry goat. I really just came home for a breath of fresh air. Like I literally just came home for a breath of fresh air, man. I know I gotta pay for my consequences, but please don't let the consequences be that severe, man. I don't want to hold you up all morning, but I just what I had to say. Thank you.
Okay. So I'm now going to inform you of my findings, okay, regarding the charges. So on charge 1 reporting, I make a finding based off of states exhibits A, D, and H. On charge 2, GPS, I make a finding based off of your testimony as well as states exhibits A, D, E, and F. On charge 3, curfew, I make a finding based off of your testimony as well as states exhibits A, D, E, and F. On charge 4, residence, I make a finding based on your testimony as well as states exhibits A and D. And on charge 5, absconder, I make a finding based off of your testimony as well as states exhibits A, D, and H. So that concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. So, Mr. Lloyd, what is your release plan? Upon release, you have a sponsor? Do you plan on going to like a halfway house? What is your plan? You talk about medication, getting back on medication. So what is your overall plan?
I got a plan. My sister lives in Southington. Like, I know that if you call her right now and ask her when she sponsored me, she'll say yeah. But if you would recommend a halfway house like Waterbury, I would go there and start doing not anger management, but mental health and get evaluated and get put back on my meds. I was taking Depakote. And then I came off of it 2018 because I felt like the dosage was too high. But if you put me back on it, I promise you I would go through the process because like I told you, I panicked when I missed my 3rd curfew. I didn't want to come out of jail so soon. I kind of panicked. And the Depakote was for like mood swings. I'm not blaming it on the medication, but I feel like it is a part of it too.
So your plan would be your sister's house or halfway house? Which would be what do you think you'll be most successful at? What is your, upon parole reinstatement, where do you believe you'll be most successful at?
I would be, no lie, I would be more successful, I would say in a halfway house.
Okay, and what area?
Sorry. Because it's step by step, but a halfway house like outside of my community, like Waterbury somewhere, like outside of Hartford, it'll be easier because it'll help me really stay focused and not be around a lot of like negative activities because I'll be able to return back to the house. I'll be able to stay out the way.
So Waterbury would be your preference of a halfway house?
Yeah, Waterbury.
Okay. And then, so it sounds like you want to go back on medication. So like a mental health evaluation to see where you stand at with mental health and medication. Yeah. It sounds like, okay. Anything else you plan on doing?
Plan on getting a job.
Okay. You have a job offer or you need to look?
I need to look, but I would go to like Trader Joe's or somewhere like a factory. It won't be hard. I'll go to like the UPS.
So your plan is to go to a halfway house in the Waterbury area so you can stay focused, stay away from around some negative activities, go for a mental health evaluation, and if it's recommended, go back on medication and look for employment.
Yes.
Anything further?
Yes, because I really I feel like, honestly, y'all got to do your job, man. I respect it to the highest, but me being in jail, like, it's not like, it's definitely correct and stuff, but I feel like at this point right here, me being in jail for another month and a half is like, it's pointless because I know where I messed up at. I know I panicked because of bracelet, and y'all punishing me further. It's like, it's extra because I get it. I understand I messed up. I know I messed up. That's what I'm saying. I know I messed up. And I'm like, I already been down almost 60 days. Another month. Not to y'all, it feel like a long time, but me being in here, going through what I'm going through, what was going on with me already from what's going on is a very long time. and it's messing with me. I just came out of BOS yesterday because I didn't feel for my safety. You could look it up. So BOS is the mental health infirmary. Feel me? I just came out of it yesterday. You're in a butt naked suit because I panicked. I thought dudes was gonna run in my cell with knives and stuff because I panicked. I don't feel like jail is like the best place for me because it's not safe in here either way, feel me? And like I said, I did some stuff with Hartford PD, so now it's like from all that's come from going on. Get what I'm saying?
Yeah.
And they putting me in jail is not the best thing for me because it's not safe in here. It's more harder to protect myself in here than in the streets. Cause all dudes do is talk and people know what happened. And I'm pretty sure y'all know what happened. Cause feel me? That's what I'm saying. I know I messed up, but I don't want to be in jail for a whole another month because it's hard on me already. And I don't want to keep running, going to mental health, hiding and stuff. It's already hard on me. That's why I would like you to please, like, your closest release date for me because it's hard in here for me, man. If you could look up the situation I just went.
But Mr. Lloyd, anything further you have? I heard you. You're starting to repeat yourself, right? You are live streamed, okay? So, anything further that you haven't already said before I announce my recommendation?
No, that's it.
Okay. So taking into account your testimony, as well as the overall history of your case, and the fact that you did say you were out only for a month and you did run, right? You acknowledge that you ran. I recommend revoke and reparole on February 10th, 2025, which is an approximate 6-month sanction. I recommend the following conditions: anger management and parenting, halfway house placement, and mental health evaluation. Now, my findings and recommendations will be forwarded to the board. You will receive a official written decision from the board, and your board review is scheduled on October 10th, 2024. So on October 10th, the board is going to look at your case again. My recommendation is a 6-month sanction, which brings you to February 10th, 2025. The board can lower that. They can agree with my recommendation, or they can exceed my recommendation. If they choose to exceed my recommendation, then another hearing, which is called a supplemental hearing, would be held. And the board will provide you with a written notice giving you specific reasons why they might want to exceed that recommendation. Okay, so you're going to receive written notice on the 10th of October 10th to inform you of what the board final decision is. Okay, so this does conclude your revocation hearing.
All right.
All right, thank you. Good morning.
Good morning. I'm sorry. I don't know why, but for some reason I cannot hear the chiming when you try to call in. For some reason, I have to walk by and see it, and I heard it hang up. So that's why I knew. I said, let me stand here. So I have
we
the one
only
guy
have-
for you.
Yeah, just one today. We'll get started in 5 minutes.
Okay.
Thank you.
You're welcome. Come in, Marino. We're gonna start in about 5 minutes. I'll have you waiting here.
Okay.
Morning.
Good morning.
We're gonna get started in a few minutes. You have to get your parole officer on the phone, and then we'll get started around 11:30.
Thank you.
Okay.
Is this Miss Jones?
No, P.O. Walker.
No, Sonia Jones.
Oh, your attorney as well. Yes, she'll be participating.
Okay.
Yeah.
All right. Thank you.
Good morning, P.O. Walker.
Good morning. Oh.
Good morning. Can you hear me?
Yes, I
ma'am.
can.
Okay, this is P.O. Walker.
Okay, we'll get started in about 4 minutes.
Okay, no problem.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning A.M.Marino, 328534. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Marino, 328534.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney as well as P.M. Walker.
Hello, Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Marino.
Natasha Walker, parole officer out of Hartford.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Ms. Marino and P.M. Walker, please raise your right hand. Please raise your right hand.
Okay.
Oh, sorry. Oh, sorry, we were frozen. I didn't see anything on Mr. Marino then. Do you solemnly swear or solemnly serious affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now review the charges that the state your officers bringing against you and the information underlying each charge. Charge 1, obedience to the law.
On 10/16/23, you went to the virtual bank teller at an Ion Bank in Farmington and cashed a fraudulent check against the real estate company Miller, Napolitano and Wolf, LLC, payable to yourself in the amount of $3,271. On 1/3/24, Farmington Police attempted to interview you, which you declined. On 1/8/24, a warrant was issued on your behalf. On 1/18/24, you were subsequently arrested and charged with larceny 3, fraudulent use of an automated teller machine, and forgery 3.
The state has filed the following exhibits, starting with Exhibit A.
Signed statement of understanding and agreement, conditions of parole. Remand to custody order. Notice of parole violation. The parole violation report. Arrest warrant from Farmington Police. Case number being 23-000-19869. And the State of Connecticut Judicial Branch pending case detail.
The state has filed an addendum to Exhibit D, which states on July 30th, 2024, Mr. Marino pled guilty to larceny 3rd and sentenced to 2 years jail, execution suspended, followed by 2 years probation. The charge of fraudulent use of an automatic teller machine and forgery 3rd were not lead. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed the following exhibits. Exhibit 1, parole accomplishments and future plans for parole reinstatement report. Exhibit 2, offender work performance and program removal refusal form for Tier 4. Exhibit 3, letter from NA sponsor, and a letter, and number 4, letter from Bryan-Marino. Today we have no witnesses, and it is now the state's opportunity to present any evidence, to speak to any of the evidence submitted.
I have nothing further to add. I think the evidence speaks for itself.
Counsel, it is now your opportunity to present evidence and speak to any of the evidence submitted.
Thank you. The addendum is stated accurately. My client does have a restitution order as a result of that case. And I would just also note that part of his defense to that case was that he was under the belief that he was working a legitimate job. Unfortunately, he was given a check that turned out to not to be a fraudulent check. Nothing further as to the charge.
On charge 1, obedience to law, I make a finding based off of Mr. Marino's conviction, as well as state exhibits A, D, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. P.O. Walker, do you wish to make a statement regarding Mr. Marino's background and history at this time?
No, just that I want to note that this is a pattern of behavior, and it's imperative if and upon release that he engage fully in substance abuse treatment and cooperate with parole services, even during periods of relapse.
Counsel, do you wish to make a statement regarding Mr. Marino's background and history at this time?
Yes, thank you. My client is 58 years of age. He's single. He does not have any children. He's a high school graduate. He's been in custody now for just about 2 years. And I think it's important to note that he did have a previous violation where he was given a jail sentence on a new case of 60 days, and he was sanctioned for that conduct to 3 months and 21 days, and he was due to re-parole on February 8th of 24, and then unfortunately the warrant in this matter that he just recently disposed of was served on him. So he has been held in custody for 2 years. He has not been released back out into the community during that time period. He received a fully suspended sentence in court, and the primary purpose of that sentence was to give him the ability to make restitution to the victim in that matter. So that's why he was given a suspended sentence with probation, so that he can make the restitution. While he has been incarcerated, he has successfully completed the Tier 4 program, attending CCAR Academy, 30 hours of training to be a coach. He's certified to be by SafeServe for culinary. He's been attending aftercare in the therapeutic community in DOC, attending meetings and addiction services. He's attending NA 3 times a week. He's on, I think he's about to start his 7th step of the 12-step program. He's been working as a tier man for over 7 months, enrolled in CDL training program. So he has been accomplishing a lot in the 2 years that he has been in custody, incarcerated. Just have one moment. When he's reinstated or re-paroled into the community, he does have plans to reside in the Middletown area utilizing a halfway house. That would be his first choice. His second choice would be to reside in the Waterbury area. He has employment where he's eligible to return to his position at Recovery on the Green. He's also amenable to all treatment recommendations, including reestablishing clinical services at Wheeler Clinic, as well as 12-step program. In addition, his future plans do include attending church twice weekly. He does have a church at First Baptist Church in Woodbury, Connecticut. It's unfortunate that he had already been through this process and that this warrant was served on him somewhat late. So we would be asking that he be re-paroled at the next available date, just noting that he has been in custody for over 2 years. The court's disposition on that underlying offense, and that it's imperative that he get out into the community as soon as possible to reestablish himself, his connections, start working so that he can start to fulfill that restitution obligation so that that victim is made whole as soon as possible. Thank you.
Walker, do you have anything else to add?
Yeah, I just want to clarify something for the record. He was remanded on December 8th of 2023, brought back in for violation. So he has not been in for 2 years. He's only been in since December 8th.
Yes, that's correct.
Oh, I apologize.
To clarify, in the PBR, it says that he was detained on October 18th, 2023 in Springfield, Mass. He has
Right.
not. So has he been incarcerated since 10/18/2023? I just want to clarify, Peel Walker.
That's correct. He came directly from Springfield to us because he was a fugitive at that point.
Okay, so he's been in custody since October 2023.
Yeah.
Okay.
So I apologize. It's 1 year, not 2.
Okay. Anything further, counsel?
No.
Okay, nothing further, P.O. Walker?
No, nothing at this time. Thank you.
Okay. I recommend a revoke and reparole on October 10th, 2024, which is an approximate 12-month sanction from the date of remand in the state of Massachusetts. I recommend the following conditions: no consumption of alcohol, halfway house placement, and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 10th, 2024. And so on that day, the board can let my recommended sanction stand, or they can impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before that hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. So that does conclude the revocation hearing at this time.
Thank you. Good luck, Brian.
Thank you very much. Thank you, Ms. Walker, too. I'll see you hopefully.
Pretty soon. Good luck to you.
Yes, ma'am.
Thank you.
Say anything.
Have a good day, miss.
You as well. Thank you.
Thank you.
Hi, officer.
Hey, how you doing?
Good, and you?
Doing all right.
We have Mr. Rogers, for 12 p.m.
Okay, let me try to get him down since you guys are on early.
No worries, we can't start till 12 anyways, just wanted to make sure we
Oh,
called.
okay, all right.
You had an answer, so yeah, if you could
Is
have him
that
up
the
at
one that you
12,
guys have to see?
that's the only guy I have to see yet, Rogers.
I got you.
Thanks.
You're welcome. I am. Hey, Gary, come on in. Come on, man. Going out. Sorry, guys. Wrong. Oh, they. Maybe I like it. Hey, Gary. Huh? Yeah, who's this for? It's for you. For you. Take a look at this. Find out. What is that? Says that you want to participate in your video.
I want to what?
Participate in your video.
Oh, this is Burl?
It is, yes.
Yeah.
Okay. Break it down one. And one.
Oh, it is? Come on, man. How do you call me so fast?
Right.
Four.
Just the agreement to participate video.
Huh? Yeah, mama, special school, that's what it is.
I know it's broke.
Huh?
I know it's broke. But they can't keep the throttle for now.
Oh.
$26 to $86. Who's upstairs and walking you, know? The officer that working there?
Rick, the lady, Rick P.
Brandon?
Yeah.
Who else is up there, you know? The other person?
It's it.
26 to 86 golf unit. Stand by for report, please.
It was a bulldog, so we don't notice.
Got it. 26 involving this player line. Hey, what are we doing as far as the count for Gary Rogers? Okay, thank you. Hey, one question, 56, that you have Belushi? Can you tell me where Belushi may have went? Everything said it's not involved. 56, maybe 56. Yes. 6, okay. Can I have him 1 o'clock video report, please? Thank you. You put them right there?
Yeah, I know. Okay.
You good, ma'am?
Yes, thank you.
You're welcome.
Good afternoon. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Gary Rogers, 161910. Today is Tuesday, October 1st, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Gary Rogers, 161910.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Rogers, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney and may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
No, I don't need counsel, ma'am.
Okay.
I don't need nobody.
Okay. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge 1, residence. On August 26, 2024, at approximately 4 p.m., you failed to return to the Roger Sherman halfway house from a community pass. Staff tried to call your cell phone and you did not answer. Staff then called the local hospitals and police departments in an attempt to locate you, but were unsuccessful. You did not notify parole on your whereabouts. On September 17, 2024, P.O. Quantita, along with other POs, were able to locate you in the community and remand you back into custody. Charge 2, halfway house placement. You were placed at the Roger Sherman halfway house upon your release from Osborne Correctional Institution on August 7, 2024. You signed a halfway house agreement acknowledging your understanding of what was expected of you during your placement there. On August 26, 2024, at approximately 4 p.m., you failed to return to the Roger Sherman halfway house from a community pass. Staff tried to call your cell phone and you did not answer. Staff then called local hospitals and police departments in an attempt to locate you, but were unsuccessful. You did not notify parole on your whereabouts. This violates your halfway house agreement, specifically that states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. The state has filed the following exhibits. Exhibit A, notice of parole violation. Exhibit B, notice of parolee rights. Exhibit C, remand to custody. Exhibit D, the connection incident report. Exhibit E, PCS signed conditions. And Exhibit F, halfway house agreement. Mr. Rogers, did you receive the parole violation report, and the other documents that were marked for identification purposes? The
Yes.
parole pack, the evidence packet, you received it?
Yeah,
Today, we have no witnesses, and it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
yeah,
Okay,
Yeah.
go ahead.
well, yeah, it's true. I didn't come back upstairs to the Rogers sermon. Well, I got frustrated because I called upstairs for them to send the elevator down to me. And then they didn't send it down. So now I gotta go back down one flight of stairs to call up again to send the elevator down to me. And then I went back to the elevator and they didn't send the elevator down to me. I got a pacemaker. And I didn't think before I react, so I got upset the second time and I left, and that's what happened. Yes, I did do it. I left. I got upset because of that fact, but I shouldn't have. But I asked them to please send the elevator down. And it's a problem with those people. They think it's funny or it's a joke, but I have a pacemaker and I can't go up on them stairs. I asked them before the last hearing, I said, could you send me to the New Haven halfway house called Walter Brooks, because it's one platform for a handicap. But they sent me there to that place and I got upset and that's what happened. And I did it.
Anything further?
No, I did it.
Okay. On charge 1, residence, I make a finding of probable cause based off of your testimony as well as states exhibits D and E. On charge 2, halfway house placement, I make a finding of probable cause based off of your testimony as well as states exhibits D, E, and F. I find that your acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait your revocation hearing.
Okay.
Your revocation hearing will be scheduled within 60 business days from the time you came back into custody. Okay.
Yeah.
You will receive a hearing disposition, which will have a tentative hearing date listed. Keep in mind, all hearing dates are subject to change. At the revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. Okay, so this does conclude your preliminary hearing. You're going to get a hearing disposition with a tentative hearing date for your revocation hearing, okay?
I'm on special parole, right?
Yep.
Oh, okay.
Yeah. So you're going to, like I said, you're going to get a hearing disposition with a tentative revocation hearing date for your next hearing, okay? And while you wait for your next hearing, you're going to remain incarcerated.
You ain't gonna let me go?
Not today. Okay, so you have a great afternoon. Thank you.
Okay. All right. Okay. Okay, you ain't gonna let me go. And I gotta wait 60 more days.
Sorry. Oh, let me talk to Burl over. And, hey, man, question for you. I wanted to ask you because you're seeing stuff up there. I got my age. This video court just, you could go send him back up. I just want to. I appreciate that. Thank you. Hold on, Rising. Hang on.
Still baby, let me come upstairs?
Huh?
I go upstairs?
Yeah, you going upstairs.
You got $1?
Do I have $1?
Yeah.
Not for you, bro.
Shoot, sure. You'll need $1 when you're drinking sippy juice.
Sippy.
I used to run action. Something to make me work.
You don't have to change, huh?
Where there's gonna be another 60 after that. You ain't gonna let me go today?
He said, you're not gonna let me go today?